So in short and in quick summary, in July 2013, 33-year-old Purvi Patel went to an emergency room at St. Joseph Regional Medical Center seeking help for vaginal bleeding. Purvi did not immediately tell medical staff that she had been pregnant, but when a doctor discovered what happened, he first called the police. And then he left the hospital to join police in their search for the fetal remains. Meanwhile, Patel remained in her hospital bed, recovering from bleeding, and when she awoke in the middle of the night, she was greeted by police officers who immediately began an interrogation. They demanded to know the identity of the father and asked, was he Indian? And was he Indian and where is he? Over and over. Purvi Patel was arrested, and the state of Indiana charged her with the crime of neglect of a dependent, alleging that she had given birth to a live, extremely premature baby and did not summon medical help for it. Later, the charge was amended to also add the crime of feticide, alleging that she had ended her pregnancy intentionally by taking medication she ordered over the internet. Purvi Patel and the expert forensic scientist who testified on her behalf maintains that she did not have a live birth. The jury ended up convicting Ms. Patel of both crimes, and she was sentenced to 30 years for neglect and 6 years for feticide, for a total of 36 years, plus 5 years on probation. 10 years of her 30-year neglect sentence was suspended, and the 6 years for feticide can be served in conjunction with the neglect years. So 20 years is what she may have to serve. So we're working hard with her lawyers to make sure she can take early parole after 10 years in this case, if we're unsuccessful at appealing her sentence outright. Her appeal is now to the Indiana Court of Appeals, and briefs are still being filed, and the court has not yet set a date for oral arguments. Indiana lawyers predict that the case will be decided sometime later in 2016. And if Purvi's sentence is not reversed, she will appeal again to the Indiana Supreme Court. She's currently incarcerated in an Indiana prison. Purvi Patel, of course, as you all know, is the first woman in the United States to be convicted and sent to prison on a charge of feticide for attempting to end her own pregnancy. Feticide laws, which were written to protect women, have now been used against a woman herself. Purvi Patel's arrests, prosecution, and conviction raise grave concerns about the selective enforcement of the laws in Indiana. The only 2 women in the whole state of Indiana charged with feticide have been Asian American women. Although abortion and miscarriage are widespread occurrences throughout the state, and Asian American women make up only roughly 1% of Indiana's population. This selective enforcement is discriminatory and unconstitutional. Unfortunately, it's also consistent with America's shameful history of passing laws based on cultural stereotypes about the Asian community and with selective enforcement of race-neutral laws against Asian Americans. 3 prevailing stereotypes about Asian Americans are particularly at play, and this is what I want to talk to you about. So one, and many of you may have heard of this myth, it's called the model minority myth. In 1966, the New York Times reporter published an article about how well Japanese Americans were doing and germinated the stereotype and myth that Asian Americans are the model minority. Quite conveniently, the stereotype had the triple effect of erasing the long history of systematic exclusion and discrimination against Asians in America, including the Page Act, Chinese Exclusion Act, and just 20 years prior, the U.S. had rounded up, interned, and sterilized thousands of Japanese American women during World War II. Second, it diminishes the Asian Americans community ability to articulate and advocate for our specific needs and wants, because everyone assumes we're doing okay. Third, it sets Asian Americans as a wedge against other communities of color, particularly African American communities. For if we're the good communities, who are the bad communities? The model minority myth makes Asian Americans invisible and underserved by our institutions, particularly public benefits, health, and mental health institutions. The second prevailing stereotype of Asian Americans is that of being the perpetual foreigner, that we're the racial minorities in the country that can't and won't fully assimilate and therefore are to be untrusted. And that's on the vanilla end of the spectrum. On the other end of the spectrum, we're seeing over-criminalization of Southeast Asians, Pacific Islanders, and especially of our Muslim brothers and sisters today. Again, hearkening to turning on the news today and hearing what people are saying about our community. Asian American women are also being singled out for reproductive injustice because of a third ugly stereotype that claims Asian women in general have a disregard for life. And so, pointing to stories in India and China, anti-choice advocates argue that Asian women are prone to child neglect and abortion. In the hospital, the officer interrogated Purvi Patel about the race of her fetus's father, repeatedly asking, was he Indian too? And we think that implies that Patel's race and the race of the fetus's father had some effect on the outcome of her pregnancy. This reflects the kind of anti-Asian rhetoric that's increasingly prevalent in the debate about abortion rights. This rhetoric was present also in discussions about Indiana's proposed ban on sex-selective abortions, which was being debated during Patel's sentencing. To support this ban, for instance, State Senator Liz Brown frequently pointed to statistics about missing women in China and South Asia, saying those cultures don't value women. And here in the United States, we don't subscribe to that judgment. The same misguided cultural connection have been used in efforts to pass such laws nationwide, contributing to the spread of myths about Asian women in our families. During congressional debate in 2012, Representative Steve King of Iowa retold the story of a World War II veteran who said he rescued baby girls who were thrown into South Asia's Ganges River. Quote unquote, that culture has arrived here in this country, he said, and this bill puts an end to that kind of culture and that would select baby girls for death. Such Orientalism and cultural misinformation has been used to pass sex-selective abortion laws in 8 states and bring them up for consideration in at least 21. But the racist accusations of proponents of these laws are false. In fact, Asian Americans have more girls than average than white Americans, according to a study by the University of Chicago School of Law. Still, these sex-selective abortion bans were the second most proposed abortion bans in 2013 and 2014. Overall, I would say these laws are a part of a broader attack on women's health and rights, which cause disproportionate harm to women of color. You'll hear more about that from Jill. And further, immigrant women, I have to say, are made even more vulnerable to these laws because they are already isolated from reproductive mental health services, a lot of services that lack the cultural knowledge and language resources to reach them. As a result, we think women may be forced to take riskier paths to end their pregnancies because of the lack of services available to them. If Purvi Patel's conviction is affirmed, we think this will likely deter other Asian American women who are struggling with serious health conditions or medical emergencies to seek out the health care they need from a hospital or clinic or a doctor, for fear that they're going to be reported to law enforcement officials. This, of course, will be particularly detrimental to those suffering from mental health problems, those who miscarry, those who suffer a stillbirth outside the hospital setting. In short, if Purvi Patel's conviction is not overturned, it's going to make it even harder for Asian American Pacific Islander women who are facing barriers to health care. This will add even more barriers. There are many barriers existent already. For example, rates of uninsurance in the AAPI community than white Americans. AAPIs are the fastest growing group of poor people in the country, and there are over 1.1 million API women living in poverty today. And again, lack of access to medical care is particularly acute for API immigrants, where rates of insurance for them is even lower, 3 times lower than for native-born citizens. And of course, undocumented immigrants are completely shut out of health insurance markets as it is, and can't even purchase health insurance, if at all, out of their pocket. This with the decline in funding for safety net hospitals providing emergency services, sources of care for the population of immigrants is dwindling. There are huge holes in our safety net already. Even those immigrants who have green cards face barriers. Almost all legally present immigrants, of course, are ineligible to receive Medicaid or coverage through children's health insurance programs during the first 5 years that they're here under lawful residency. This 5-year ban has a significant impact on women who make less money than men, require health services, more health services than men do. States, of course, may choose to waive the 5-year ban for immigrant pregnant women and immigrant children, but not all do. And as of January 2013, only 20 states have opted to provide this gap coverage. Indiana, I'll note, is not among them. Language and cultural barriers also prevent AAPI women from accessing medical care. 71% of APIs speak a language other than English at home, and 32 are limited English proficient. Language barriers, as you can imagine, make accessing care a challenge from the start to finish, from finding a facility to booking an appointment to talking to your healthcare provider to getting the knowledge you need. Lack of cultural competency amongst healthcare providers is another barrier. APIs are more likely to distrust their healthcare providers due to insecurity around their immigration status. The Department of Health and Human Services in 2012 conducted a study that found that fear of mistreatment and deportation, we know, deters immigrants from seeking services already because it might bring them in contact with law enforcement. So if Purvi Patel's conviction stands, it will confirm the fear that many immigrants already have around the intersection of health and law enforcement. And giving legitimacy to Purvi Patel's deplorable treatment by her healthcare providers in Indiana law enforcement will only serve to make it even less likely that immigrant API women will seek out care and treatment when they need it most. So instead of criminalizing Asian American and immigrant women with these onerous laws, states really should be creating culturally competent and sensitive resources that help them safely exercise their reproductive rights and access quality mental health care. NAPAWF is proud to have led an amicus brief signed on by 21 leading national Asian American organizations, laying out and agreeing to the argument that we just made. And we want to thank our partners for standing with Purvi Patel and for standing on the side of justice. Before we go today, and I hope this message gets reiterated, I want to invite each and every one of you who are on this webinar to join us in finding justice for Purvi Patel. One important step each and every one of you can help us take is to share her story. Share Purvi's story. Injustice must be named for it to be corrected. We must speak her truth while she's in jail so that Purvi Patel can be the first and last woman to be jailed under feticide laws. With that, I want to pause here and turn it over to my excellent colleague, Jill, who will take us even further into this discussion.
Thank you, Miriam. On behalf of my co-authors, Melissa Meixel, Wendy Fu, Laura Paul, and Shivana Jorar, I want to thank the 30 organizations that signed on to this brief to support Ms. Patel. We are honored to have the faith and the trust of the RJ community to write this groundbreaking brief. We hope our arguments will engender compassion for Ms. Patel and enlighten the judges about the need for self-induced abortion and the destructive and discriminatory consequences of upholding her conviction. We hope that our brief, in unison with all the others, will convince these judges and their peers in other jurisdictions that when a pregnant person exercises their fundamental constitutional and human right to abortion, they should be left alone, not locked up. We know from communications research that there is a lot of ignorance surrounding self-induced abortion. Assuming the 3 impaneled judges in Indiana share some of these misunderstandings and misgivings, we decided to address them as foreground in our brief. Many people assume abortion without medical supervision is automatically dangerous. So we begin by describing the commonality, safety, and efficacy of self-administered medication abortion throughout the world. And Jamie, I think it's time to move to the next slide. As most of you are likely aware, an abortion can be successfully self-induced using misoprostol alone or in combination with mifepristone, which is the standard regimen when it's prescribed by a medical professional. And there may be other forms of self-induction that are also safe and effective as well. We know there's a great deal of confusion in the public about why anyone would choose to prompt their own abortion, based on perceptions that everyone would prefer the care of a trained medical professional and that abortion is readily available. And this, of course, stems from a lack of awareness regarding obstacles to clinic-based care. And so we walked the judges through the various reasons why self-induced abortion may be the only accessible or acceptable method of abortion for many people. We focused on poor and low-income communities, immigrants, and communities of color. because social science research suggests the practice may be more common among these groups, because people from these communities have been targeted for arrest and prosecution for self-induction and other pregnancy-related crimes, as I know Sara will elucidate, and because these are Ms. Patel's communities and identities. We discuss the legal restrictions, financial barriers, and practical obstacles that limit access to abortion, paying special attention to the Hyde Amendment and other restrictions on public and private insurance coverage. We made it a point to highlight the laws, coverage bans, dearth of providers, and poverty levels in Indiana in order to drive these points home for the judges. For example, Indiana has a mandatory delay, biased counseling, and ultrasound requirements. It also has a prohibition on the use of telemedicine for medication abortion. It follows the Hyde Amendment and prohibits coverage of abortion in private insurance. We know that 61% of women in Indiana live in a county without a single provider, and that over 43% of people in the state are living resource deficient. In addition to material and logistical barriers, culture may also propel people toward ending pregnancies on their own. As Miriam illuminated, new immigrants may struggle to navigate the unfamiliar and complicated systems of insurance and medical institutions, leading to misunderstandings, frustrations, and certainly substandard quality of care. They, like many native-born residents, may be confused about the legality of abortion, much let alone the various intricacies of it here in the US. In their countries of origin, self-directed health care, including self-induced abortion, may be the custom, born of either preference or necessity, and what they would naturally gravitate toward here in the US. And of course, immigrants aren't the only people who may have a cultural appreciation for at-home care over hospitals or clinics. Self-directed care may be a requirement of someone's belief system or expression of their values for self-empowerment. They may want to self-medicate using misoprostol, vitamins, herbs, or natural remedies because they view these methods as more natural and less invasive physically than a surgical abortion. They may prefer to stay in their homes with their chosen company and avoid the aggressive taunts and other stigmatizing behavior of some clinic protesters. And finally, we know that there are many communities, particularly communities of color in the US, who've been exploited, coerced, and abused by the conventional medical system. There are also individuals who felt disrespected and mistreated during medical office visits. So it's understandable why they would fear and want to protect themselves from further mistreatment, especially under the circumstances of such a potentially intense and intimate experience as abortion. We go on in the brief to argue that if courts criminalize the only available or accessible method of abortion, they effectively prohibit exercise of the abortion right. You cut off the method, you cut off the right. And then we pivot to the second section where we shift the focus to the repercussions of criminalizing Ms. Patel and other people in similar positions. Allowing prosecutors to link alleged self-induced abortion with feticide will no doubt have cascading consequences for all pregnant people, particularly those from marginalized communities. If the court allows the state to criminalize abortion self-induction, more people will be forced to carry pregnancies to term. This, we know from social science data, exacerbates poverty and its effects. We explained to the judges that by upholding Ms. Patel's conviction and creating a new category of feticide for self-induced abortion, they will be perpetuating the culture of surveillance and repression of pregnant people. They will encourage the police state, media, and everyday folks to further scrutinize every act or omission by a pregnant person, just in case they might be motivated to terminate that pregnancy. The more people we put under a microscope, the more prosecutions for pregnancy loss we'll have, intended and unintended. We know that almost a third of pregnancies end in miscarriage, often with an unknown cause. So we're talking about a lot of people who could potentially be ensnared in the criminal justice system, and that is a grim, though plausible, picture. Finally, we explain how the restrictions, the surveillance, and the criminalization have to and will continue to disproportionately impact and unfairly target immigrants, communities of color, and poor and low-income people. Why? 3 major reasons: poor birth outcomes, exposure to law enforcement and other state agents, and racial bias, including over-policing in communities of color. So first, because these communities tend to have worse birth outcomes, resulting from a variety of socioeconomic factors, including housing and food insecurity, work conditions, racism, and structures and systems structured to provide inadequate or inequitable care, information, and resources, which Miriam spoke to earlier. Second, because these communities have heightened interaction with state authorities. They may experience pregnancy loss or abortion in a more public arena, given proximity to neighbors in multiple family housing units, the prevalence of police in their neighborhoods, and regular interaction with government agents. And third, because of racial bias, over policing in communities of color, and the disproportionate arrests of people of color for pregnancy-related crimes. In conclusion, for hundreds of thousands of pregnant people, the only way to exercise their fundamental right to abortion is to muster the ingenuity and courage required to take care of their own needs without medical assistance. It's unethical to criminalize people who cannot otherwise afford, access, or navigate clinic-based care. Instead, politicians, police, and judges must respect this fundamental right that everyone deserves to hold equally. And to allow those who must rely on themselves to end a pregnancy to ensure that they may do so with dignity, free from the threat of prosecution. Now, many of us in the movement are concerned about the rise of threats related to abortion self-induction. That's probably why we're all here together today. And our concern is motivated in part by the mystery surrounding self-induced abortion's legality. In response, our organization, Courage, is leading a consortium of 9 legal organizations that is plotting the legal landscape of abortion self-induction to ensure that women in the U.S., people in the U.S., can end their own pregnancies without threat of arrest for themselves or anyone who assists them. Together, we're conducting urgently needed research into the potential legal implications for those who provide, possess, or ingest abortion medication for self-induction, as well as those who relay information about it or provide care to people before, during, or after taking medication to end a pregnancy on their own. Beyond investigating the current state of the laws, we're also exploring novel legal theories, long-term policy changes, short-term defenses, and protections for mechanisms of information relay and drug distribution. Our colleagues in this include Law Students for Reproductive Justice, National Advocates for Pregnant Women, Reproductive Health Technologies Project, Legal Voice, California Women's Law Center, Gender Justice, Southwest Women's Law Center, and the Women's Law Project. You'll be hearing more from us about this as soon as we have information ready to share. And right now, you'll be hearing from Sara Ainsworth from National Advocates for Pregnant Women.
Please let me know if you have any trouble hearing me. It's very nice to talk with you today, and I thank NAPAWF for pulling together this webinar and for all the work of our colleagues, and to those of us who are on the phone who have participated in or joined this Amicus effort or have been publicizing or talking about the case. Thank you so much. Miriam's exactly right. We need to share Purvi's story so that we can prevent this from happening again. So what I want to talk today about is a little bit about the Amicus effort that we pulled together for Ms. Patel, and some of the cases that at NAPW around the country regarding the criminalization of pregnancy, whether you're looking at pregnancy outcomes like miscarriage or stillbirth, or whether somebody has self-induced an abortion. I see that there's a quick question there from Jessica at RH. We actually have a link right there on the PowerPoint slide. If you go to that link, you can read all 5 of the Amicus Briefs filed on behalf of Ms. Patel, and you can also read her lawyer's opening brief filed on her behalf, which I encourage you to read because it is a beautiful work of art in a very difficult case. So I'll just quickly tell you what those briefs are, and then I will talk primarily about NAPW's brief and the background of some of these cases that came before. So really quickly, what you're going to see when you go to that link is the brief that Miriam described that was filed on behalf of API organizations and leaders and experts around the country. You'll find the brief that Jill was describing that was filed by Courage on behalf of numerous reproductive justice organizations. You'll find NAPW's brief, which was filed on behalf of public health organizations and also some constitutional organizations, including the ACLU and Planned Parenthood. And you will find a brief written by the International Women's Human Rights Clinic at CUNY Law School. So Cindy Suhu is the author of that brief, joined also by the Center for Reproductive Rights and Amnesty International, that describes why the prosecution of Ms. Patel is a human rights violation. And then finally, there's a brief that was filed on behalf of the Innocence Network. You may be familiar with the Innocence Network as the organization that fights to address wrongful convictions throughout the United States. The Innocence Network is very interested in the kind of evidence that's used to convict people, and so they challenged the forensic testimony that was brought against Ms. Patel through the prosecutor, primarily the use of what is known as the lung float test, which is a disreputable, disregarded, and ancient test used to determine whether a baby was stillborn or born alive, essentially floating its lungs in a glass of water. And that has been rejected both by forensic scientists around the United States, but also around the world. And unfortunately, that was a part of what the forensic expert that was testifying against Ms. Patel used to justify his assertion that that she gave birth to a baby that lived for just less than 1 minute. So that's the amicus briefs that you'll find there. And then I would like to talk about first the background of Indiana law and what we've seen before to women, that happened to women previously before Ms. Patel's arrest. As Miriam mentioned, the only other woman to be charged with the crime of feticide in the state of Indiana in relation to her own pregnancy is a woman named Bebe Shui. Ms. Shui, who National Advocates for Pregnant Women represented, was accused of the crime of feticide and murder for trying to commit suicide while she was pregnant. Ms. Shui had become very depressed. She had been struggling with the relationship between herself and the father of the baby. She'd been struggling financially, and she was in a deep depression when she tried to commit suicide by consuming rat poison. Friends of hers discovered what she had done and rushed her to the hospital, where thankfully she was treated and was able to survive. She stabilized, but gave birth to her baby 4 days later. Her baby lived for approximately 3 days and then died. While mourning the loss of her baby, she was arrested and put in jail without bail, because in Indiana, if you're charged with murder, a judge cannot let you out on bail, essentially. So she was held in jail for over a year pending these charges. There was, in that case, like this one, a major effort on the part of organizations around the United States to provide amicus in Bebe's support. Ultimately, the charges of murder and feticide were dropped in exchange for Ms. Shui pleading to a lesser crime, and she was released on time served and is no longer under the jurisdiction of Indiana. Thinking, that would be, we nonetheless were watching what had happened since that time. And that's because not only did you see charges of feticide brought against women like Bebe and Ms. Patel, but in Indiana, as in other states all over the country, prosecutors have sought to use laws that are not designed to target pregnant women against them. So in Indiana, prior to these two cases, there was a woman charged with murder for suffering a stillbirth. There was a woman charged with the same crime that Ms. Patel was charged with, neglect of a dependent. She was charged with that crime for consuming cocaine during her pregnancy. Her baby was born alive, but tested positive for cocaine. It is not uncommon at all in National Advocacy for Pregnant work for us to see crimes charged against women who have used some kind of drug during pregnancy, but it doesn't necessarily stop at that. As you can see in the two cases we're discussing today, and in Ms. Patel's case, once you start making the things that happen during pregnancy a crime, you essentially open up anything that a pregnant person does during pregnancy to the possibility of investigation, arrest, surveillance, and prosecution. So our amicus brief sought to highlight that explicit fact and to raise some of the constitutional arguments that are necessary to indicate how not only will women have to be vigilant about everything that happens during pregnancy, but they're essentially treated as if they are people without civil rights. So they acquire a second-class status during pregnancy if you create a legal regime that targets them for prosecution for anything that happens during pregnancy. So briefly, one of the things that we wanted to highlight in our brief and that we'd really like to share with you today is the fact that if you look at the statements that are made by anti-abortion groups all around the United States, they have been saying this for decades. Over and over again, you will see the people that oppose abortion saying, when abortion is banned, when we overturn Roe, we will not put women in jail for having abortions. Women are the victims of abortions. We will only put the abortionist in jail. So that's the rhetoric, that's the language. I'm sure many of you have heard that before. We brought all of that to the attention of the court in this case and said, look, if you look at the statements of bishops and popes and legal scholars who are opposed to abortion, women's groups like Susan B. Anthony List that are on Feminists for Life, and all the organizations that talk about how important it is to ban abortion, over and over again they say, we don't want to see women go to jail. So we highlighted that to the court not only to show them that this is something that no one saying they want, nobody wants to see this, but we also highlighted to show our advocacy community that this is a lie and we need to make sure that we're calling out groups on that, because that's precisely what will happen when abortion is banned. And in our brief, we talked about the terrible results you see around the world of abortion bans. So in El Salvador, for example, there are 16 women now, there were 17 women serving lengthy prison sentences for having miscarriages. Abortion is entirely illegal and not available under any circumstances in that country. And women are going to jail for both having abortions, for attempting self-abortions, and also for miscarriage. So one woman, Carmen Guadalupe, who was 18 years old when she suffered a miscarriage, went to prison in El Salvador and served 7 years of a 30-year sentence before she was pardoned because the evidence showed that she had had a miscarriage, that she had not attempted an intentional termination of pregnancy. In Ireland, where abortion is banned, many of you know the story of Savita Halappanavar, who in October of 2012 was miscarrying and sought care in a hospital because the doctors could still detect a fetal heartbeat, and because abortion is against the law and doctors go to prison in Ireland if they perform abortions. The doctors at the hospital refused to treat Ms. Halappanavar, and she died as a result of their failure to care for her and provide the care that she deserved and that was necessary for her health. As you all know, there's outcries in all of those countries about these kinds of cases we're describing. We hope to see the same kind of outcry here around Ms. Patel's case because it's the same kind of injustice. And it's, even though we're in a country where abortion is ostensibly illegal, we all know that the restrictions, as Jill so helpfully pointed out, the restrictions, the bans that are in Indiana and in many other states make it harder and harder and harder for people to get what they need. We also talked about the fact that Ms. Patel is not the first person to be criminally charged in the United States with having an abortion. She is the first person where a state used feticide as the charge against her. But Jenny McCormick in 2011 was also arrested and charged with a crime. She was charged with having an illegal abortion, so essentially violating the state of Idaho's abortion ban, which had been in place since Roe and had never been removed from its books. Ms. McCormick, her circumstances were almost identical to Ms. Patel's. She the only real distinction besides race and ethnicity and where she lived was that she was already a mother of 3 children. But like Ms. Patel, she sought abortion-inducing drugs over the internet. She induced her own abortion around the same time in pregnancy that Ms. Patel did, and she was arrested and charged with a crime. Very quickly after she was arrested, a lawyer filed a civil rights brief on her behalf and brought a case on her behalf against the state to try to stop the prosecution. In response, the prosecutors dropped the charges against Ms. McCormick, and then the case proceeded on to the Ninth Circuit Court of Appeals, which held that it is an undue burden on the abortion right to make it a crime for a woman to induce her own abortion. So that Ninth Circuit ruling applies across the West Coast. It doesn't apply in Indiana, although Indiana looks at other federal circuit courts and may be persuaded by that reasoning. But we wanted to make sure that that case was brought to the attention of the Indiana court, and especially its similarities to what happened to Ms. Patel. We also argue that it violates the rights to equal protection. If you set up special crimes that are only for pregnant people, you've created, as I talked about earlier, a second-class status for people that starts not just really when they become pregnant, but really applies to anyone who has the capacity to become pregnant. And we talked about what we're seeing all around the country. Women who have been prosecuted for not wearing a seatbelt and then getting in a car accident and then suffering a pregnancy loss. Women who have been prosecuted for using drugs during pregnancy, like taking half a Valium late in pregnancy, to being on prescribed methadone for an opioid dependency. People who've fallen down the stairs and been accused of trying to terminate their own pregnancy. And at every stage of the proceedings, what you see is the involvement of healthcare, of people who are supposed to provide confidential health services, in turning people into law enforcement. So with that, our final point of the brief was that public health is not served when you target people who are pregnant for prosecution and punishment for the outcomes of their pregnancies. If you do this, you will discourage people from seeking medical care when they need it. You will discourage people who've had a self-abortion from, if they have any complications, from getting the health care they need. You will discourage essentially people from doing what exactly we need them to do in order to ensure the best outcomes for pregnancies. So with that, I will wrap up and happy to take questions when we're done.
Hi, everyone. Hi, everyone. Everyone hear me okay?
Everyone hear me okay?
My name is Shelly Dodson. I'm the National Program Director with Backline, and I call Indiana home. Backline is an organization that provides unconditional and judgment-free support for pregnant people and their loved ones across the full spectrum of pregnancy decisions and experiences. At Backline, we know that pregnancy often shines a bright light on a woman's life. It reveals the strengths and challenges in their relationships, their beliefs and feelings about pregnancy, parenting, and family, and their hopes and goals for the future. It also shines a bright light on the options and opportunities that she has or doesn't have as a woman living in a society that does not support all decisions, all people, or all communities equally. And we believe that pregnant people deserve our support, not recrimination, judgment, or jail. And that's why we're here today, to stand with Purvi and in opposition to the grave injustice against her. And what really makes Backline unique is that for more than 10 years, we've been working to support people in all of their messy, complex experiences with pregnancy options and decision-making. That includes pregnancy loss, infertility, abortion, adoption, and parenting. And the fact that we have an equal willingness to support and discuss or not discuss all pregnancy options and experiences, regardless of the choices made or considered or how they feel about it. As I said, for the past 10 years, we've been providing unconditional and judgment-free support on our national toll-free talk line.
We receive hundreds of calls every year from people all across the country who are struggling to find a safe place to talk about all of their experiences and feelings around pregnancy, parenting, abortion, and adoption. Our callers tell us how rare and important it is for them to find this kind of open-hearted support where they get to bring their whole selves to the conversation. At Backline, someone can talk about their recent miscarriage as well as an abortion they had 2 years ago and never told anyone about. They can talk about how being an adopted person complicates their feeling around an unintended pregnancy and their experience and their options in that. And they can talk about how messy and complex all their feelings are about their decision to parent or to have an abortion. These are a couple statements from callers who have called the talk line just to talk about how profound this experience can be when we're met with dignity and respect and compassion versus judgment and recrimination and stigma. Being able to call Backline today made such a difference. When I called, I was crying and upset and really felt like I had no options. The conversation helped me find the courage and strength to do what is right for me. I'm surprised something like this exists. I've been going through 11 awful weeks and felt so grateful to have someone who is open to talk to, who is open, understanding, and generous with help working through what feels like the most painful moment of my life. And finally, it was a relief to talk to a non-judgmental person. She really, really listened to me and what I was saying. It was amazing and made me feel at peace. And I think what we've been talking about today really highlights the fact that there is a lack of safety in being able to talk about these pregnancy experiences, and that is compounded by many factors, and oftentimes people don't have people in their lives to talk to us about. And so thinking about who calls the talk line and who this is available to, and so it's not available just to people in Indiana, it's in fact available to people all across the country, which makes it such a great resource. So who calls the talk line? In short, everybody. Anybody and everybody can call the talk line. And so most of our calls really are around people seeking or considering abortion. They're calling for all options pregnancy counseling or after abortion support. Michael and his wife just found out that she is pregnant. They are exhausted and struggling to take care of their 3-year-old and can't imagine having another child, but thought they would never consider abortion. Angel is confident in her decision to have an abortion and has family support. Her partner, however, has threatened suicide if she ends the pregnancy. Sandra is married with 2 teenagers and had an abortion last week. She felt fine after an earlier abortion at 19, but this one has been harder for her. She wanted to make sure we were pro-choice because she had had bad experiences with the resources she had tried so far. And these are just a handful of the people that call us, and we know that this is a common experience, and what's uncommon is the fact that we're talking about it or that there's a safe space for people to get support. The other thing that we do, the second program that we have at Backline, is professional trainings. And this is where we really bring together counselors, educators, healthcare professionals, and advocates to explore their values, to learn about current practices in abortion, adoption, and parenting, and to share tools and skills for offering open-hearted and unbiased support for people across the full spectrum of these decisions and experiences. Because we know that biases and assumptions matter, and that when we work through our own experiences around what we feel about these issues and what we feel about certain experiences, we're able to really let go of our investment in other people's lives and decisions and to really be present and engaged and fully supported with an open heart and an open mind. And what's really exciting about the work that we're doing is the fact that we just launched All Options Pregnancy Resource Center in May here in Bloomington, Indiana. And so, unfortunately, this isn't an opportunity for everyone in the country to reach out to, but it is if you're living in South Central Indiana. And so for years, we've really been dreaming about opening a brick and mortar space, and we knew it would be an exciting way to support people in a deeper way, more resources and community support and in person. And we know that there's real comfort and power in being able to gather our communities together for face-to-face support and identifying solutions to the problems we're all facing together. And a pregnancy resource center really felt like the perfect model for that. And All Options, I can't emphasize this enough, it's like the first of its kind. It's a very unique center because we are truly supporting people in all of their options and all of their experiences. So in addition to material support like diapers and baby clothes, we also make referrals for birth control and abortion, and we're in fact starting the first statewide abortion fund. because we trust people to make the best decisions for themselves, and we believe that everyone deserves support, no matter what decisions they make about pregnancy and parenting. We know that at least 61% of women who have had an abortion have already given birth to at least one child, and that these are not separate needs, and that families can need both diapers and formula and referral for abortion and abortion funding. And All Option has been here for them through every pregnancy and parenting turning point. And these are some of the services that All Options offers: free pregnancy tests and counseling, free peer counseling support. We offer secular support groups, material support, abortion funding, referrals. We offer new opportunities for people to become engaged in this movement and encourage networking and community building through trainings, workshops, and events. And by the numbers, I think this is very exciting. This is from last month, so the numbers are even higher, but we've been able to give out over 1,500 packs of diapers to families in the past since we opened in May, which is a huge need for people because we know that, again, these needs do not exist in silos. And who visits the center? It's going to be just like the people that call the talk line, just like all of us who need support around all of these messy and complex experiences that we have. Juliana is taking care of her 3 grandchildren so that her daughter can maintain custody and have a relationship with them. She didn't anticipate being a parent again at her age and is struggling to fill in the gap to support them. Chandra just found out she's pregnant. She and her husband are overwhelmed and struggling to take care of their 3 young children under 4 years old and can't imagine having another child, but never thought they would consider abortion. And Petra wanted to talk about her birth experience. Her daughter is now almost a year old, and she hasn't been able to talk to anyone about her traumatic birth experience. She feels as though it is impacting her ability to be a good parent. And as Jill and Miriam and Sara have talked about, that these cases are becoming more and more common, with people being punished for poor pregnancy outcomes. And the burden falls hardest on women of color, young women, people in rural and marginalized communities. It is so terrifying to think you can fall under suspicion for having a miscarriage or stillbirth, and that any indication that you were ever ambivalent about being pregnant or that you were ever even considering an abortion could be used against you. There are already so many assumptions about how people should feel about being pregnant, or that they are ever and biases about who should and shouldn't become a parent, usually based on all kinds of racist, classist, and ageist ideas. And all that judgment and stigma makes it so hard for people to find support and help when they are faced with a difficult situation. We believe that people need and deserve to find the care that they need to be safe and supported. And all the judgment and stigma can make people feel isolated and desperate and lead to unnecessarily tragic outcomes. And by prosecuting Purvi Patel, the state of Indiana is telling anyone who is or might be pregnant that you don't deserve help, you don't deserve dignity, you deserve jail. And we're here to show our support for Purvi and for all pregnant people, and to tell the state of Indiana that pregnant people deserve support and not jail. So here's our information about for anyone that ever needs support in any of their pregnancy and parenting experiences. Thank you.
Great. Thank you so much to all of our panelists here. I'd like to be mindful of the time. We don't have very much time left, but I would like to go ahead and acknowledge all of the individuals and organizations that signed on to the various amicus briefs in this case. And I would like to also go ahead and ask a couple of questions in the few minutes that we have left. So we have a question for you, Shelly. Has Backline received calls from people who are exploring self-induced abortions?
That's a really good question. I do think as we continue to have more and more restrictive laws and more restrictive access to obtaining abortion care, that more people, that's something that they're looking into. We haven't had a ton of calls that I'm aware of that have really called in someone asking how to self-induce an abortion. So, and we definitely want to make sure that people are getting safe and getting the support and healthcare that they need to make the best decisions for themselves, and that we really trust people to do that for themselves.
Great, thank you. And in just a few minutes that we have left here, would like to ask the question, how is it that Purvi was charged with 2 conflicting charges? So she was charged for feticide and neglect of a minor. How was that argument made?
I'll take that one on. Her lawyer argues, and I think correctly in his brief, that these are contradictory crimes and it's really not possible to be charged with both. Either a feticide has happened, meaning the death of a fetus in utero, or a live birth happened and there was neglect of the living baby, which are, so the 2 crimes are totally contradictory. But the way the prosecutors explained the theory is that attempting to terminate a pregnancy, so essentially terminating the pregnancy and ending it regardless of what results at birth, is feticide. And one of the things that this case will test is how well that argument will fly with the courts. And I also want to point out that what's particularly alarming about that is that once you make that argument, again, what is an attempted abortion? Is attempting suicide an attempt at terminate an abortion? Therefore, feticide is eating something you're not supposed to eat. Any kind of reckless conduct, does that rise to that level? And so the range of conduct and omissions that a pregnant person could be held criminally liable for is vast under this theory.
Great, thank you so much for that, Sarah. I would like to go ahead and say that if you would like to be kept informed on this case, and just be mindful of the time, and if you have any additional questions, please feel free to contact the panelists. And I will also be sending out a follow-up email to all of our guests today, and with the link from National Advocates for Pregnant Women with all of the briefs included in that, and following up with what's happening in Ms. Patel's case. And as we talked about earlier, if you are angered by what is happening with Ms. Patel and you believe this is an injustice, share her story, talk about her case to other people, because that's the best way that we can raise awareness about what is happening in Indiana and other states as well. I would like to thank you all for joining us for this webinar, and I would like to thank the panelists again for taking the time to speak with us today. And please feel free to contact us with any other additional comments or questions that you may have. And I think that this time we'll just go ahead and wrap up and have a great rest of your day. Thank you.